the basics of copyright law.
Copyright. Noun. The exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something, such as a literary, musical, or artistic work. Merriam-Webster Dictionary.
That seems like a simple definition, right? Well, there might be a few experts who can say they fully understand all aspects of copyright. I mean, they could say it. But let's face it, many more people do not grasp even the basics. But before we delve further into what copyright is, let's briefly discuss why it matters. What exactly is the purpose of copyright? Although the arguments for copyright vary greatly, the two primary rationales are the utilitarian perspective and the argument for authors' rights. The utilitarian rationale is more commonly associated with the common law tradition, while authors' rights is historically identified with the civil law tradition. Jeremy Bentham, who once said, "It is the greatest good to the greatest number of people, which is the measure of right and wrong," may have argued for copyright from a utilitarian perspective. A utilitarian would likely believe that copyright incentivizes creators. A utilitarian would also see copyright as a way to focus on the social benefits of creative works. And even a utilitarian, like Jeremy Bentham, would likely believe that the social benefits of copyright also includes the potential commercial gains for creators themselves. The author and playwright Oscar Wilde, who once wrote that art is the most intense mode of individualism that the world has known, may have argued today that the rights of the authors should be one of the primary purposes of copyright. This perspective centers around the idea of recognizing and protecting an author's connection to his or her works. It ensures that the author is given proper attributions, and that copyright preserves the integrity of creative works. But first things first, how does an author go about getting a copyright in the first place? Well, the first requirements for copyright in the United States were codified in the late 1800s, and for almost 200 years, obtaining a copyright became more and more complicated with each copyright-related amendment. At times, authors had to deposit copies of their works in various places like district courts and dedicated copyright offices. Public notices had to be made in newspapers. Copyright notices had to be included in or on the published works themselves, and even more types of requirements that vary depending on the type of work being copyrighted. So, yes, for a long time, it took a lot of time and a lot of work for authors to copyright their creative works. But that largely changed with the passage of the Copyright Act of 1976 when, among other substantial changes, Congress decided that copyright began immediately upon the work's creation and its fixation in any tangible medium of expression. But what do we mean when we say something is in a tangible medium of expression? What is copyrightable? Most of us probably know that literary works can be copyrighted, so that one is easy. But what about music? Well, sound can be recorded in various forms, so musical compositions can be copyrighted. Also, dramatic works in tangible forms, like scripts, can be copyrighted. Visual art can be copyrighted. Choreography can be copyrighted. Works like sculptures can be copyrighted. Photographs can be copyrighted. And what do they have in common? They are all creative works recorded in a tangible form, be it on paper, an audio recording, a video, a digital copy on a hard drive, etc. But a creative work isn't copyrightable just because it's in a tangible form. It must be, as the term says, creative. So things like facts cannot be protected by copyright because they are not created by anyone. They exist independently of any individual's creativity. They are discoveries or truths about the world that are not subject to personal authorship. Similarly, ideas cannot be copyrighted because copyright law only protects the expression of ideas in a tangible form, not the ideas themselves. Take, for example, this image depicting Albert Einstein thinking about his famous discovery, the theory of relativity. The theory of relativity is an idea, so it cannot be copyrighted. However, the unique way that the artist of this image expresses that fact is copyrightable. But since we're talking about copyright, of course, it's not that simple, at least not in this case. This image of Einstein would be copyrighted if it had been created by a real person. Yes, this was a trick example because as you can see from the citation, this image was created by AI. Although this is still being debated in courts today, AI-generated images are generally not considered copyrightable because they are created without human creativity, which is a key requirement for copyright protection under current copyright law in the United States. But it can get even more complicated than just that. In 2011, British wildlife photographer David J. Slater became embroiled in a copyright dispute when a monkey named Naruto took a selfie using his camera. Animal rights activists sued on Naruto's behalf, claiming that the monkey owned the copyright, but the court ultimately ruled that animals cannot hold copyrights. The case highlighted complex issues surrounding authorship and copyright law, particularly regarding works created by non-human entities, even if they are living and breathing. But for the purposes of continuing our look into the purpose of copyright law, let's assume that this little guy is a copyrighted work. Does that mean no one else besides the author can use it? Nope, there are exceptions. One major clarification from the Copyright Act of 1976 was the definition of fair use, a concept that originated in English common law, where courts recognized that certain uses of copyrighted works did not constitute infringement if they were reasonable and did not harm the market value of the original work. However, although the term had been used before, it was not codified until 1976, when Congress provided a clearer legal framework and formal recognition of fair use.
Purposes such as criticism, comment, news reporting, teaching including multiple copies for classroom use, scholarship, or research is not an infringement of copyright.
Like so many things related to copyright, fair use is complicated and often misunderstood. Part of this confusion is due to the fact that there are no strict rules when it comes to determining fair use, because each case can be so radically different, making it impossible to have a one-size-fits-all definition. Instead, 4 factors are typically used to assess whether a particular instance qualifies as fair use. First, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market value of the copyrighted work. Finally, it should be noted that all works do eventually enter into the public domain, meaning they are not protected by copyright because their copyright term has expired. Anyone can use, reproduce, and adapt works in the public domain freely without seeking permission or paying royalties. This allows for greater creativity and innovation, as individuals can build upon these works without legal restrictions.